Welcome to section 4.2, part 4. This is the 32nd session of the CISSP exam prep series. This part rounds out our legal tour with workplace privacy and the international rules. In this session, we'll cover privacy at work and the major privacy regimes beyond the United States. We'll answer several questions. When can an employer monitor its people? What makes the European approach different? What core rules does its flagship regulation set? How does data move across borders under that regime? How is artificial intelligence being regulated? And how do other nations protect personal data? Why does this matter beyond the exam? Because your users and your data rarely stay in one country. Picture a support team in one region reading messages from customers in another, all stored on shared systems. Whether that monitoring is lawful, and whether that data may even cross the border, depends on rules that differ sharply by nation. Guess wrong, and the fines are steep. When can an employer monitor its people? Whenever there is no reasonable expectation of privacy on company equipment. Courts protect privacy, but only where a person could reasonably expect it. A sealed letter carries that expectation. A postcard does not. On employer-owned systems, courts have found employees generally cannot expect privacy, so routine monitoring is allowed. But the employer must remove any hint of an implied expectation first, through policies, contract clauses, and login banners. Think of a warning sign posted at the door. Once everyone is clearly told the space is watched, the expectation of privacy disappears. What makes the European approach different? Its breadth. Where the United States stitches together narrow, industry-specific laws, the European model is comprehensive and applies to almost all identifiable personal information. It does not wait for a particular sector to be at risk. Instead, it sets one broad standard for handling personal data across the board. Picture the difference between many small fences around specific fields versus a single wall around the entire property. The European instinct is the wall. What core rules does its flagship regulation set? A handful of principles that govern every use of personal data. You must have a lawful basis and be transparent about processing. You limit data to the specific purpose you disclosed, and you collect only what you actually need. You keep it accurate, and you keep it no longer than necessary, honoring a person's right to be forgotten. You secure it, and you take accountability, meaning you must be able to prove your compliance. Crucially, the regulation reaches any organization that handles data about its residents, even one based elsewhere. Think of these as 7 house rules that follow the data wherever it goes. How does data move across borders under that regime? Only through approved channels, because sending personal data out of the region is tightly controlled. A company can adopt standard contractual clauses, which are pre-approved terms it drops into its contracts, or it can build binding corporate rules, an internal rulebook for transfers between its own units, though that path is slow and mostly used by very large firms. An older safe harbour arrangement between the two regions was struck down by a court, so companies can no longer lean on it. Picture a border crossing that only opens for travellers carrying one of a few specific pre-stamped passports. How is artificial intelligence being regulated? Through a risk-tiered framework that sorts systems by how much harm they could do. The most dangerous uses, like social scoring, are simply banned. High-risk systems, such as those in hiring or critical infrastructure, face strict duties around data quality and human oversight. Limited-risk systems, like chatbots, mainly owe transparency, so users know they are talking to a machine. And the vast majority, minimal-risk tools like spam filters, carry no extra obligation. Think of a traffic light system for algorithms, where the colour depends on the stakes if the system gets it wrong. How do other nations protect personal data? With their own comprehensive laws, most echoing the same core themes. A regional economic group publishes a voluntary privacy framework to ease trusted cross-border flows. Canada's law governs how commercial businesses collect and use personal information, with some provinces running their own equivalent rules. China's law demands explicit consent, limits collection to what is necessary, and tightly restricts sending data out of the country. South Africa's law sets multiple conditions for lawful processing, with special care for sensitive data and children. The pattern is unmistakable. Around the world, the same principles keep reappearing under different names. Think of many countries independently arriving at the same short list of fair data rules. So let's bring it together. Employers may monitor company equipment once they remove any reasonable expectation of privacy. The European approach is comprehensive rather than sector by sector, and its flagship regulation sets a handful of binding principles that follow the data anywhere. Cross-border transfers out of that region require pre-approved channels, and artificial intelligence is governed by a risk-tiered framework. Other nations, from Canada to China to South Africa, echo the same core privacy themes. Learn the shared pattern, and you can reason about a law you have never seen before. The MCQs covering all the topics and concepts from this session are available on rucloud.com. Practice the chapter-specific MCQs before moving on to the next session. Thanks for watching. If you have any questions or feedback, post a comment below or email us. I will see you in the next session.